Well, thank you very much, and the privilege is mine to be affiliated and being a research fellow of the Institute. And it's obviously also my privilege to be here and be able to share the work we're doing in the Caribbean. I think we need to put a little bit of context to the research. And the title of today's talk is perhaps to make you think about what we're doing in the Caribbean, particularly the idea of that one can deconstruct something that was built by the British Empire. And I use the word deconstructing in both its meaning, the deconstruction in the critical socio-legal sense, of being able to identify in a critical way factors underlying certain social legal trends, but also deconstructing in the sense that we are actually, putting things, taking these little pieces by pieces, in order to make them right, from at least a social legal perspective, not necessarily an ontological perspective, but a social legal perspective. So it's something to think about, and hence I would like to give you a bit of a background here, because I guess when we think of when we think of the British Empire, I guess anybody who have done a bit of A levels and have looked at the history would have been taught that a basic principle of the British Empire's laws, which were laws that only involve the intersection between the empire and the colonial territories, to the extent that it was important for the empire to have them. Otherwise, it has always been similar to Roman Empire laws, as a matter of principle, that the empire power will allow the colonial territories to carry on with the culture's more laws and traditions, right? So perhaps one of the main reasons for the success of the British Empire has been to follow on the prior biggest empire of the world, which was the Roman one, in that the Romans will, refrain from legislating or imposing Roman law on the territory they were conquering. And the British followed similar traditions in that regard. And of course the caveat is the same is here, unless it was in the economic or political interest of the empire's authority. And so I guess most of the texts that trying to link empire's way of dealing with sexuality, the British Empire's way of dealing with sexuality, will actually tell us, and that is an important book written in the 90s by a chap called Hyam, Hyam, about empire and sexuality, which I recommend. I think it's an important text to understand the way in which the policies underline the different laws. And there is an important thing that he says there, in that, from his perspective, when we look at the way in which prostitution, sodomy was regulated by empire's law, because again, remember the background principle. From the perspective of the British Empire, there will be no regulation unless there was something of interest. So where is the interest? Where was the interest of the empire to regulate areas which are clearly a matter of social development for the colonial territories, right? And so this scholar here will actually say that the interest there was twofold. On the one hand, it was the protection of the British people, right, from the more sexual morals and customs of the colonial inhabitants, right? I guess, just to put it in a very blunt and black and white way. There's no black and white in social science, but I mean, just for the sake of the example, basically, we don't want our soldiers, our Navy boys, to be able to do overseas what they are not able to do in motherland, right? So engaging in homosexual conduct, which was probably punished by death, was not something that they would actually, the empire would like the young British boys to engage in those far away lands. So that could explain the reason why. There is also another important aspect of it, and that is the power of Christianity opened the empire, and the possibility of trying to make uniform in an area that is important to the empire a homogeneous way of dealing with this topic or this subject even. I think that explains, and this is not my theory, so I am happy to refer you to the author if you want to expand a little bit more on that. If you want to expand properly on that, not a bit more. But that's sort of what him, if that's the correct way to pronounce his last name, is telling us. Now, I think, in light of what I have already done for the purpose of this research in the Caribbean, that there is other grounds to explain this that are not alternative, but perhaps could actually supplement this to try to understand that, and also sort of now heading towards my subject for today, which is deconstructing what has been done. Beyond the aspect, the social aspect of sexuality, its criminalization falls squarely within the criminal laws of the realm. And there is a very important aspect that we need to understand from the legal perspective now, that wherever the common law develop, the courts will actually become somehow, and probably I would fail a legal paper if I were to say this in a legal paper being asked a question, but we can argue that the courts in the common law system could actually be seen as a lawmaker as well. In fact, it was not until 1990 that the House of Lords actually withdrew from the courts the power to make criminal laws, right, by means of case law. So then we can enter into debate here whether case law is actually legislating or is actually interpreting what there is, and coming to a conclusion that may actually impose a new conduct. But without going into that philosophically, if you want, legal philosophy conundrum, we know that the courts in common law have the power, by interpretation, of setting up new standards, if we don't want to go all the way to laws, but at least new standards of conduct. So not just principles, but just standards, right? We're going to move in a little bit further from principles into standards. And the fact is that wherever the British Empire ramifications went, the common law grew as part of that model. And so the English criminal law was almost reproduced in every state, if you want, of the United States, even though the United States technically is not a part of the Commonwealth, right? But it still is a common law jurisdiction. And the English criminal law also, because of the court system, would actually set roots in almost every single country that was a colony of the British Empire and today is a nation state, of which we can count around 45. So, and when it comes to criminal law, there was another, this common law effect will provide the empire with a great opportunity. And here's where the link with the background comes. if you have already the criminal law being somehow spread by the activities of the courts that follows a particular model, which is the common law model, then to a certain degree you are achieving certain homogenization between the center of the empire and the colonial territories. Now, we need to put this in context of what was happening in Europe. And today's lecture may actually even give us a sense of why the British are so adverse to the European Union as well. And you will see why. In the mid-19th centuries, the European powers were consolidating themselves as nation states. We're talking about almost half a century after the big revolutions that actually brought an end to the absolutism of the royal houses. That is the French Revolution and the American Revolution. And so, almost half a century after those revolutions, what we have is a nation state that are consolidating the power. What is left in absolute arbitrariness is the judiciary. Maybe we will look at the best example here, the German judiciary, for instance, with absolute powers worse than the common law judges to do as they wish. And also, they will depend on the different big royals, because the German monarchy was an elective monarchy. It was not necessarily hereditary as we have it in the UK. And so, the nation state that were growing, they realized that they needed to withdraw that discretion from the judiciary if they were to grow and consolidate as nation state. And this is what is going to start with what is referred to as the big codification, the school of codification. That never crossed the channel, because here the courts remain powerful, and although the politicians in parliament wanted to adopt that that codification, we know that in the UK we never had any code, any civil code, any penal code, any labor code. Legislation was never codified by parliament. I mean, I remember when I was teaching criminal law, the best example of this is that the criminal offense of murder is nowhere defined by legislation still today in 2018. Right? Murder is a common law offense, properly speaking. And in order to understand what murder is as an offense, homicide, you need to go and pick elements from case law over the last 300-400 years, right? In terms of what the offense constitutes, what the defenses that there are, etc., etc., etc. So the politicians, and particularly the establishment, realized, well, we need to convince ourselves of this tool of codifications. What we can do is to try it in our colonies. We have the basic elements there because the common law has expanded there. So why don't we just codify the common law and see how it works in the colonial territories? And therefore, two big code or models code evolve out of this experiment. The one that will actually be exported and imposed in the East Indies, Asia, and then eventually taken to Australia, New Zealand, and the one that will be actually brought, which was a different model written by a different person, to the West Indies, which is today the Caribbean region. And there is a fascinating research done by a professor in Oxford a couple of decades ago about these codes, which is very interesting because it actually is a sort of legal historical research. And it does somehow share with us what was going on by actually having look into the archives and look at the letters, the exchange of letters between. It's a fascinating article because it gives us a sense of what was going on in the mind of the government at that time. And there is a very interesting letter of the chap who actually produced the model code for the Caribbean. When he was invited by the Colonial Office, as he was referred to, today we call the Home Office, there was at that time a Colonial Office, to draft a code for the West Indies, he replied that he has notions as to the manner in which a criminal code should be drawn, and I should be glad to test them by an experiment at large. So there was no shame at all at that time in actually discussing openly that what they were actually doing, beyond of what this scholar Hyam said in The Empire and Sexuality, was also a social legal experiment. And again, that article, the reference to which I can provide you later with, is a very interesting article because it's a very good, nice research in which actually it's called A Forgotten Chapter in the History of the Criminal Law by a chap called, professor actually, called Freeland, professor of Oxford. It was published in 1981. So that's the background of the research. This is what we are deconstructing. We are deconstructing a social legal experiment, which for whatever reasons, whether it was to protect the British soldiers from the mores and customs of the colonial territories, or to export sexuality as defined by Christianity, for whatever other reason we may want to accept that there was a clear policy government here of trying something that was never implemented in the UK. Even today, 2018, we still have no codification. Even most of the world have moved towards that by now. So this is the background. So let's talk now a little bit about the research. So the purpose of the research is, as I explained, is to look into this construction that was brought as a social experiment back in the middle of the 19th century to the West Indies. And particularly we are focusing on the criminalization of a section of the community. That is, technically defined, is the criminalization of sexual activities between adults, consenting adults of the same sex. That is what is criminalized. I guess that technically that is what sodomy laws are. Is a criminalization, the provision by a criminal law of sexual activities. They don't have to be sexual intercourse, properly speaking, but in general sexual activities between consenting adults of the same sex. And what we're trying is to ascertain what are the social legal impact of this law, not necessarily only on the population being targeted, that is, in modern terminology, LGBTI people or individuals, but also in the population at large. I'll give you an example of the effects later, because it also impacts in the way in which the population at large behave, or the way in which the population at large can actually work within a civilized society. It's not just only affected the population being targeted or their families and friends. There is also an effect of the population in general at large. The focus of this research is divided in two, and this was more than anything an issue of fundings. We applied for certain money which we didn't get, so we needed to focus on 3 rather than the 11 countries that still have sodomy laws in the American continent. All of them share the same heritage. They're all former colonies of the British Empire. They're all now nation states. And we focus on 3 of them for the purpose of conducting a field research, that is actually being in the country, interviewing people, interviewing the government, interviewing organizations. And those 3 countries that we have decided to use are Barbados, Guyana, and Jamaica. Sorry about the pronunciation, but it tends to be push to my Spanish way of pronouncing the names of these countries. They actually give us an exposure, particularly because of the social legal impact assessment that we want to conduct here, to 64% of the 11 jurisdictions that still have sodomy laws. In relation to the rest of the countries, the other 8 countries, what we're doing is conducting a desk research. So I am in charge of having under my management a group of virtual researchers who have actually helped us to reach out and gather information. But also I have myself, as you will see, reach out to important number of institutions and NGOs and government agencies in these countries in order to gather as much information as we can from my desk. That's what's called desk research. And then use that information to conduct the social legal assessment that we are aiming to do with this research. So how is this research structured? There is a protocol of questions that has been elaborated by a research committee, of which I am a member. There are other people who are members of the research committee. There are people representing the different sponsors. So the money to conduct the research has come from the International Bar Association. It has also come from a United Nations institute that deals with criminality in Latin America and the Caribbean. And there is a chairman who is one of the judges of the Inter-American Court on Human Rights. He has been appointed chair of the research committee. So this research committee elaborated a protocol of questions, which was then validated by a scientific committee that we appointed that is trying to represent the region at large, split gender-wise, but also a split in many other diversity aspects that we felt are very important to legitimize the work that we are conducting in the region. And the total question that we have elaborated were 54, divided in 5 areas. The areas are criminalization, access to justice and judicial system, violence and discrimination, and equality, and finally transgender individuals. The idea of these questions is to try to extract as much information as we can in a methodical way that would allow us to build a picture that will provide an objective, as much as possible, idea of the situation of LGBT individuals in the region. In order to achieve this, we have the research committee have made an aim of the researchers, whether these are the people working in Jamaica in the field, Guyana or Barbados, or whether it is myself with my virtual team of researchers, to at least target 10 organizations per country. And the idea is to have a similar ratio in terms of targeting the government, targeting NGOs like LGBT people, but also target the private sector. It was important for us to gather as much information and cross-refer the information that we were gathering from different walks of life, different economic sectors of the society we're actually researching, to get the most accurate picture of the jurisdiction. In total, and for the purpose of the field research, I target out of I have 8 countries in my portfolio. I target 93 organizations, trying to respect that 33%. We send them the questionnaire for them to answer between November and December last year, and they were given until the end of March this year to give us answer. In February, we'll remind them of the deadline. And the next table will give you a breakdown of the replies and the success so far. Success in a narrow sense. I guess if you look at the 1, 2, 3, at the fourth row, the one with totals, you will see there are 93 organizations. I got 51% reply. So basically, they're having to my 93 letters, I got 48 letters back. And of that 48 letters back, 30, that is 32%, confirmed that they were keen to participate. And of those 30 that confirmed that were keen to participate, only 20 submitted a report by the end of March. So we have a 21% success in the amount of information we're expecting to obtain. Now, if we extract the government, because the problem with the government, as you will see in the row number 2, government sector, you will see that the government submit nil reports, right? Although we have 2 government agencies from 2 countries who were keen to submit a report, they end up not submitting anything at all. So if we take out of that and say, well, we're left instead of 93 target organizations with 69, so we take the government agencies, then the success is 30%. And with 30%, we were relatively happy that we were able to process the information obtained from 30% of the organizations. I was personally happy. I did not expect to have a success rate above 35%. But the coordinating committee felt otherwise. And particularly the coordinating committee, in light of the lack of engagement by the government agencies, it felt that there was a need to engage the government or give the government one more last opportunity to engage. And so I've been asked, given the task to contact against the government, and this time to contact to try to put more political pressure on them, which I did during the course of the summer. I got the reply from 2 head of state, the head of state of St. Lucia, 2 governor generals, the head of state of St. Lucia, and is a queen actually. The governor general of St. Lucia, who actually is keen to provide us with information. I gave also the governments the opportunity to narrow the report to very specific aspects rather than answering the 54 questions, and also provide the governments with the opportunity of a report ad hoc or informal. Because I do understand that these areas are, sometimes politically difficult. And for our perspective, what we would like to have is information. And in order for us as social scientists to be able to build a picture rather than, blaming or raising fingers against anyone in particular. The other country that replied was Trinidad and Tobago. So St. Lucia and Trinidad and Tobago are the two countries that seems to now being engaged. So that is positive, and we're looking forward to see the reply. They have now until the end of this year. So as a consequence of this delay, we are probably 6 months behind our schedule. We were meant to start drafting our report this summer. We are unlikely to start before January 2019. It's not bad, but it is what it is, and it's better to try to have a more accurate picture by engaging the government rather than to rush into write a report. So far, and with this I finish, and I'll actually open the floor for questions. What are the preliminary results that we can share with you? Because, as I said, we have, depends how you count, between 20 and 30% of organizations who have submitted an answer. I think a couple of things that we can easily spot here is that since we started the research, I mean, we can actually see important contrasts here between the Latin American Caribbean, or Latin America in general, and the British colonies, which somehow confirm a research that was done 4 or 5 years ago by a pair of British Cambridge professors, academics, in which they came to the conclusion that the countries that were part of the British Empire were more likely than not to have still criminal laws that criminalize homosexuality. And if we look at the Caribbean, is not particularly different in that the 11 states that is still criminalized, and I put 9 in with a question mark there, because since we started the research, we have 2 decisions of 2 courts, one in Belize and the other in Trinidad and Tobago, that declared those laws unconstitutional. So the one in Belize has been appealed, not the substance, but a particular aspect of the judgment by the government. We have actually assisted to a very important difference to be made in the case of Belize, about which I can talk more about later, by engaging with the Vatican itself, because one of the appellants was the Roman Catholic Church. So I'm happy to share a little bit of more information about that later. And the other is Trinidad and Tobago, where the court in Trinidad and Tobago also, as was saying before we started, found the sodomy laws unconstitutional. Now the government is appealing, but the appeal is strategic. The appeal is strategic and is to a certain degree with the consent of the applicant, because the idea is that this becomes a binding precedent, not only for Trinidad and Tobago, but also if certain conditions are met from the common law perspective, it will become a binding precedent for all jurisdictions whose final court of appeal still remains the Privy Council in the UK. For those who are not familiar with the concept of the Privy Council, former colonial territories that are nation states, not all of them, but I think there are, I mean, you must have this better number than I do because I haven't looked at that, but I think there are 12 or 14 countries out of 50 Commonwealth countries that, after breaking from the UK and becoming independent nations, have kept as a final court of appeal the Privy Council of the British monarch, which used to be in colonial times the final court of appeal for them. So they have kept that court as the final court of appeal. The members of the Privy Council are similar to those of the United Kingdom Supreme Court, so the appeal is more likely than not to uphold the decision of Trinidad and Tobago Court But I mean, with judges, you can never say, right? But in principle, it's unlikely that they're going to reverse it. And if they do so, chances are that and is doing it in a particular way, chances are that that is going to become a binding precedent for all countries, which are 12 or 14, that have kept still, even though their nation stays independent, the Privy Council or the Final Court of Appeal. An interesting contra that is clearly now evolving out of this research is that we don't have this system in Latin America or in the Latin Caribbean, right? And the few countries that did criminalize homosexuality, and you have the case of Ecuador, Colombia, and Chile, for instance, they did that not as a matter of adopting the offense from the empire from which they were breaking, but they did that as nation states. Later on in their life, Chile was the first Latin American country to do it, actually, and that was in 1871 with the adoption of the first penal code. They did it, and the other two countries, which are Ecuador and Colombia, they did it in the 1930s, but for reasons which are more a matter of following the different school. Latin America, as I guess it may be the case with other parts of the world, tend to look into Europe for models of laws. And at the point in which Ecuador and Colombia were looking for a penal code, a modern penal code, in the 1930s, the professors of law in the main faculties of Ecuador and Colombia happened to be very good pupils of a rather fascist professor of Italian criminal law, who had actually drafted a penal code for Mussolini. The history is fascinating on this. In his draft, he actually have introduced sodomy laws in Italy as a draft legislation. When Mussolini saw that, he said, well, that's ridiculous. We don't have homosexuals in Italy. Delete that. And hence the penal code that was brought during Mussolini times in Italy basically did not have the sodomy that was proposed by the drafter. But the professors in Latin America who are following this chap from Rocco was his name, and hence the Rocco Code is referred to, did actually cross the Atlantic and I was passed by the parliaments in Ecuador and Colombia. But the point here to be made is that they did not inherit it, right? This is not something that was imposed during colonial times and they kept it. In these cases, they actually adopted, and in some cases, as the case of Ecuador and Colombia, almost 150 years after they broke the chains from the Spanish crown. I think a last point that I could share with you is, which I think is interesting from the social-legal perspective, but from the legal perspective, but it also have a social connotation here. When we look at the draft codes, as I explained to you, the two main draft codes that were used by the British to impose criminal laws in a codified way in the empire were two. One written by James McLaughlin and the other by Robert Wright. The one of McLaughlin actually was important for the East Indies, Asia, Africa, and Australia later, and the one for the West Indies, the Caribbean region, is the one by Wright. Now, there's another interesting finding because, obviously, all of the nations in the Caribbean actually refer to Wright as the father, the drafter of the code that was actually brought there. So that basically took me to look actually properly into the actual code that was drafted by Wright, and then just to compare whether it was the same that was actually being enforced. I'm a rather inquisitive researcher, so when I saw this, I said, well, let's see whether the actual draft, was the same. At the end of the day, Mussolini did actually, veto the sodomy laws in Italy for whatever reason. Doesn't really matter. The drafter proposed something, the legislator did not follow. So I was curious as to know whether the same had happened somehow in relation to the draft proposed by Robert Wright. And it actually happens the other way around to a certain degree. Not that Wright did not propose the sodomy laws, but he proposed it. It's very interesting. If we look at the draft code, the code that Robert Wright submitted to the Colonial Office, he differentiates from the McLaughlin draft that was imposed in India and then from there to the rest of the East Indies, colonial territories, in that if we look at McLaughlin Code and the final code approved by the Colonial Office for the West Indies, the sodomy offense remains an offense against the human body. So this is a very important thing. For those who are not familiar with codification follows certain logic. And so if we look at the penal codes until 1980s, 1990s, the first chapter of the penal code will deal with crime against the state. Why? Because from the legislator perspective, when codification started in the middle of the 19th century and for almost 150 years, the state was the most important thing to protect. And so the first chapter reflects the importance of what is being placed there. Then you have crimes against the person, and then you have crimes against property in general, right? Just to give a sense of how a penal code is structured. So where to place a particular criminal offense is giving you a sense of the importance of that criminal offense, or how much the legislator want to prevent that from happening. In the case of sodomy, the Colonial Office, similar to the model that was exported to India and Australia, places the sodomy offense in offenses against the human body, so in offenses against the person, right? And of course, this is a very important chapter because it's the first chapter that deals with crime other than crimes against the state. And the punishment is basically life in prison, right? If we look at Robert Wright, he drafted, in his draft, the one that he submitted to the Colonial Office, he disagreed with that, and he places the sodomy in the chapter which comes after crimes against the state, after crimes against the person, after crimes against the property, in the chapter that has to do with public nuisances. And if we look at the punish he suggests 2 years penalty, right? He's talking about, I guess, sexually. I mean, it's sodomy with consent and bestiality. I'm not so sure why he did that. I mean, traditionally in the Middle Ages, sodomy, bestiality, and having intercourse with the Jews was also part of the similar criminal offenses and often was punishable by death, right? So if we look at 12th century criminal laws in Europe, you will see that bestiality, sodomy, and intercourse with a Jew will actually be found as a capital offense. So I guess he followed that model, but the important thing here is that he distinguished between consent and no consent. I mean, sodomy without consent is rape, right? it's talking about sex without consent. So, and hence, it follows similar punishment to rape, punishment by penal servitude in his model. But he created this idea that sodomy with consent is still punishable, is a public nuisance, and it makes it punishable by 2 years. The Colonial Office code imposed in the West Indies doesn't follow that. Ditches did, in the same way that Mussolini ditched the suggestion of Rocco in Italy, but goes the other way around. it goes harsher, and it adopts basically the model that was imposed in the East Indies. So this is another interesting finding so far that I can share with you about the research. There's a final thing here, but more than anything for you to think about, right? I mean, I really have no much to say at this stage, other than what we're talking here when we look at the criminalization of a section of the society, of the community, as it happens still in 9 countries in the Caribbean region, where you're talking is the institutional state using its power to target it against a section of the society in a mechanical way. There is very little different with the apartheid policies in South Africa, or if you want the final solution in Germany. The philosophy of it is using the machinery of the state, the power of the state, to target it intentionally against a section of your civil society. We're not talking about crimes in the context of a war. We're not talking here about. We're talking about basically your civil society, and when we look at this in that way, what we are seeing is that we're having here the elements of a crime against humanity, which is prohibited under international law. Many of those treaties that prohibit this type of activities by the states have been signed by countries that are still criminalize LGBT people. So that's something to think about. Are we actually able to conclude that sodomy is a crime against humanity? That's a question open. And regardless of that, is it time for an apology? The Prime Minister of the UK thought that it was enough time after 200 years, almost 150 years, to give an apology, and she gave it on behalf of the UK to the Commonwealth Head of States gathering in London in April this year. So that is welcoming. But what happened with the country that still are reluctant to stop this persecution of their civil society? Is it time to pay compensation? Who is going to pay that compensation? I mean, the Germans pay a huge compensation for the atrocities they did in the Second World War. The Americans pay compensation for the atrocities they did to the Japanese people in their own country during the Second World War. They apologize for slavery and segregation even in the United States.
When did they do that?
Sorry?
I'm American. I missed that. They made an apology.
They apologize.
They made an apology
for slavery. Yeah. So, and that's very recent, so perhaps you miss it. It was, I can tell you, the House of Representatives apologized in 2008, a resolution of the House of Representatives in the United States. So now we have the UK apologizing for the codes that actually, by ways of bringing a social experiment, impose in the British Empire, in different versions of it. And so is it time for an apology? Is it time perhaps to think about compensation, particularly in circumstances where countries are reluctant to stop this activity that it may be construed as a crime against humanity? I don't know. These are open questions. I don't have a conclusion. It's just as the research progresses and as gathering more information, the picture is building in a way in which, as objective as one can be in the circumstances, is providing interesting data to think about. So I stop here. Sorry, I was going to spend 10 more minutes than I thought, but apologize. But I'm happy to answer questions that you may have. Thank you.